and now we'll go a bit to the legal side of sustainability. So we talked about litigation a bit earlier, and now we'll go a bit deeper in the subject with Clifford Chance and a great panel. So because yes, ESG and climate litigation risks are not longer theoretical, but they are really shaping boardroom and balance sheet. So I have the pleasure to welcome three partners for Clifford Chance. Ada Schmitt, she's a partner in Luxembourg in litigation and dispute resolution. Maren Stadler-Tjan, also partner in Luxembourg in asset management and sustainable finance. And Daan, sorry for the Lunsingh Scheurleer, partner coming from Amsterdam. So I'm sorry, Daan, because I didn't see you earlier to have the opportunity to ask how you to pronounce your name. But thank you for coming from Amsterdam for this event, and welcome. And
no worries. It's a secret sauce the Dutch have to be able to pronounce my name. So no worries if you can't.
But thank you for coming from Amsterdam. And the floor is yours.
Thank you very much, and good afternoon, ladies and gentlemen. My name is Maren Stadler, and I'm absolutely delighted to be moderating the panel on ESG and climate litigation risks. As already said, I'm joined today by two of my partners, litigation dispute resolution partners, Ada Schmitt, being based in Luxembourg, and Daan Lunsingh Scheurleer, I hope I did pronounce it right, being based in our Amsterdam office. I tried at least. So as you have already heard earlier today, the Sustainable Finance Disclosure Regulation is currently undergoing a lot of changes, and we are of course monitoring this here in Luxembourg really closely, because this is going to have big impacts on the asset managers and the investment funds that we are setting up in Luxembourg. So under the current rules, funds and asset managers, they have to disclose to what extent environmental, social, and governance-related aspects are taken into consideration when taking investment decisions, and the pressure of investors to receive some sort of disclosure remains of importance and high. At the same time, these asset managers now have to push down these obligations to the asset level, because this is what the obligations actually entail. And the information that is being received is partially maybe not comparable, incomplete, even though we do see clear improvements on that level. And why are we talking about that is because these obligations are there, even though the obligations are not really clear. There's a lot of different interpretation of the rules. With whomever you speak, you actually probably hear something else, especially on these famous Article 8 funds that are out there. And this is, of course, of concern of companies and asset managers, because the question is, what's the risk for these type of companies if the rules are not so clear? And as we, of course, also know, at the same time, there are developments in the United States, the election of the latest administration, taking an entirely different stance to the financial sector when it comes to ESG considerations. And especially for global companies, asset managers, but companies overall, they are asking themselves, so to what extent can I now comply with the rules? Do I have to comply? How does it impact my operations and also my investors? And this is leading to a so-called ESG backlash. So during our panel discussion, I don't want to talk about the regulatory framework, because already this has been covered, and this is not the idea of the title of the panel, but we really would like to understand what now the current environment creates in terms of ESG and climate-related risks in the environment, and we do want to focus on 4 key areas, and this is civil claims, greenwashing, shareholder and capital market action, and project planning. So now, Daan, if I would like to start to talk about the civil claims. So civil ESG and climate-related cases, what types of cases do you actually see when you talk to your clients?
Thank you, Maren. And thank you, to the organizers for having us. I'm a civil litigator. I represent clients in the civil courts of the Netherlands. I will try to say a bit about other courts, like administrative courts as well. We'll turn to that later. Before I answer your question, Maren, because we're actually focusing, of course, on claims against companies, against private actors, I think it's good to take one step back. There are actually sort of two distinct types of cases if you look at who the defendants are. There are cases against governments and there are cases against private actors. And of course, very famous examples of cases against the governments was sort of the leading first case where a government was court-ordered to reduce emissions. That was the agenda case in the Netherlands that went all the way up to the Supreme Court, which was basically mimicked, if I dare say so, in the Swiss case of the Klimasenioren that went up to the European Court of Human Rights last year. And you see a lot of sort of similar cases being brought as well in Belgium and in other countries. And those cases are, I think, very distinct in a number of aspects from the cases against private actors. And why is that? Because a government has legislative power in its territory. It can regulate the subjects in its country, be it companies or private citizens, and create level playing fields by imposing rules and regulations that apply to everyone or that at least apply to all companies in a certain sector. And if you look at the vast package of legislation that, for instance, the EU under the former Commission was able to pass through the European Parliament under the terms of the Fit for 55 package, you can see a very sort of integrated, well-balanced approach that is either sectoral-based or economy-wide based. If you look at cases against private actors, the claimants are targeting an individual company, but that individual company is, of course, not acting in a vacuum. It is active in a competitive environment. If it's a listed company, it is subject to the rules of the capital markets, and it will need to make money in order to be able to survive, because a bankrupt company, whatever you would like companies to do in terms of ESG, is not able to do that because it will just be broken up by a liquidator. So the trick there, I think, is for individual companies to find a pathway that allows them to be compliant with all those rules, and they differ across the world, but also to be profitable in order to be able actually to make that difference. And that is why my personal view is that I think cases against governments are sort of fundamentally different from cases against private actors. Now, what do you see? And now turning to your question, Maren, I'm sorry for this sort of wider expose first, but I think it's important to bear that in mind. If you turn to cases against private actors, at least if you look at cases in this part of the world, there are civil cases that that seek redress in the form of compensation for damage incurred or threatened damage. And that is a very recent and famous example was the case brought against the German utility RWE by a Peruvian farmer who claimed that as a consequence of global warming, a glacier near his village was melting and therefore was threatening his fields. That case ultimately was thrown out on the basis of an assessment by the court based on expert evidence that the likelihood of that individual actually being harmed by the melting lake, the lake of melting water, was actually quite remote, and therefore the case faltered on causation. But the German court, there was the higher court in the region of Hamm, actually held that as a legal basis, there could be a liability on the part of the company. Now, that case cannot go up to the German Supreme Court because of German procedural rules. Other examples are, for instance, cases that are now announced that will try to build on the findings of that court on the legal thing, and they will just find another farmer whose fields are actually threatened by rising melting water. The other type of relief that you find is sort of injunctive relief, where you seek a court order, where claimants ask the court to impose an order on a company, you should not do this or you should achieve that. And there you see a number of things. You see, on the one hand, redress being sought to the effect that the company reduce its emissions, not only its Scope 1 emissions and 2 emissions, but also reported Scope 3 emissions, to the extent that a company does in fact report them because the rules are not uniform, as you know, or refrain from investing in certain industries. A case in point being 2 cases in the Netherlands, in one of which I was personally involved. So that's a disclaimer, and I shan't discuss that case at length because I don't feel at liberty to do so. But there was a case against a major oil company, an oil and gas company, where the NGO claimants sought a reduction percentage to be imposed on the company of 45% by the end of 2030 as compared to 2019 on a net basis across all reported scopes. And a new case by the same NGOs being brought by a major financial institution, ING, where they seek similar reductions, but also a court order that says that the bank should stop investing or help clients investing in new oil and gas projects. So that is, I think, also an example where claimants actually try to build on previous cases and to sort of see where they can find a new avenue of seeking redress. The case against the oil company got thrown out on appeal, whilst it was successful for the claimants in the first instance. And the reason why I can't talk about it much further is because it's now pending before the Dutch Supreme Court. So that is, I think, one important distinction. So the type of relief and the type of defendant. And you alluded to that, Maren, already. I think there's another important distinction as well, and that's the direction of travel. And to latch on to the Marconi quote that the previous speaker just said, that humanity or mankind is the biggest enemy, but also the best hope for the planet. It's exactly that chasm between those 2 elements of the human condition. And we see that happening in other geographies where there are simply other values and other views on what the role of a company is and what the role of an investor or an asset manager is. And that is increasingly, as we talk to clients, increasingly a concern for companies to navigate those dire straits, if I may say so, because you need to be compliant. There's all kinds of regulatory enforcement if you fail to meet the regulatory requirements. But if country A says you need to go left and country B says you need to go right, or you need to go up, or you need to go down, that's hard to reconcile, especially if you're corporate. If you're offering investment funds, I'm not an investor, but I could imagine that you could offer a fund doing A and you offer a fund doing B, and then you can be friends with everyone. It's not as simple as that, I think, but especially our corporate clients do struggle with this. So that's my answer to your question, Maren. Thank you.
Yeah, thank you very much. And I think it's a very interesting perspective because we don't yet see, let's say, in the asset management world, a lot of greenwashing claims, but I think it's also because there's not yet the rules that are, where everyone agrees that this is the rules that everyone needs to comply with. So I think it's a really interesting perspective to see what is happening at corporate level and what are actually the claims that we see are happening. So maybe staying on the same topic, so how does the backlash affect civil liability exposure?
Well, of course, the diversion in the direction of travel is relatively new still. So basically, you're asking me some crystal ball gazing, and predicting the future is always a difficult thing. But I think it will just be a matter of time before someone starts litigation against an asset manager saying you do too little to advance ESG investing, and then the next day someone will come along and say you do too much, and that is that is something that I think at least you need to spend a bit of thought on as to how you would respond to that, again, it will be trial and error. It is quite clear if you look at the way in which across the globe, not only in Europe, but also in New Zealand, in Australia, in Asia, and also in America, many of these cases are being brought against a variety of defendants and on the basis of a variety of causes of action. And claimants are learning from each other and they're building on each other. So at some point, someone will be successful. At some point, someone will get a asset manager into a tight spot, and then you need to deal with that. But how? It's really dependent on what the actual claim is, what the facts underlying the claim are, and what the profile of the defendant is. And one of the things that I always say to clients when I talk to them, part of litigation preparedness in this area is to make sure you really understand your own value chains. You understand, you are able to explain what you're doing and why you're doing it. So that is, I think, the starting point for that.
Thank you. So now moving over to greenwashing claims, which is not a very easy topic because the question is always, so what is actually greenwashing? So Ada, from a litigator's perspective, what constitutes greenwashing in the current climate?
Thank you, Maren. I think it's really interesting because in 2025, probably the concept has become more complex and more fragmented than what it was when it first came about. I think we all know greenwashing as referring to exaggerated sustainability claims, but today there is a second aspect to it, and that is really failure to disclose limitation or trade-offs that you might do when pursuing ESG strategies. And that you can really see translates into enforcement action and litigation, because on the one hand, I think by now we're all familiar with the regulatory enforcement action against including asset managers for overstating ESG integration. And there have been landmark cases in this respect. But equally, and going to the second acception of the term, there is now a trend of green hushing. So companies or even asset managers really deliberately downplaying or removing ESG language to avoid political and legal risk. And as Newsweek reported in April of these years, of the S&P 100 companies using ESG in their annual sustainability report, 40% were using ESG in the title of that report in 2023 still, and now it's dropped to 6% in 2025.
Thank you very much. I think what we are experiencing is now really NGOs or investors focusing on consistency, so looking at the names of entities or funds, looking at the disclosures, looking at websites, and to look at whether it's really done by the asset manager, what is written in the documents. So I think this is maybe the interpretation just from the fund's perspective on what we see at the moment as greenwashing claims. So what is, in your view now, considering the change in the ESG world, the backlash, as I've called it earlier, influencing greenwashing litigation, Ada?
Well, I think Interestingly, there are two currents that are emboldened by this duality of the concept. On the one hand, you still have very tight and determined regulatory enforcement with respect to misleading ESG claims. I'll just give you one example of the Australian Securities and Investment Commission. They had a case against Vanguard Investments Australia that was resolved in September 2024 and terminated in a 12.9 million penalty because it was considered that the way that Vanguard presented their application of exclusionary screens was misleading for investors. So basically the claim or the conclusion was that for a specific fund of theirs, it was advertised to investors that specific screening was performed to exclude investments in certain business sectors, such as fossil fuels at the time, but that actually this was not really the case, that those screens were not applied, and that in some instances, 74% of the securities in that specific fund had not been applied the screens advertised. And then going from there, the feeling or the conclusion was that there had been capitalization by the asset manager on that on this practice by attracting investors and sort of enhancing their reputation, whereas had they been more forthcoming about their screening, probably the same reputation and investor attraction would not have been achieved. So that is the one current. And then on the other hand, you have really anti-ESG actors using litigation to challenge the very existence of ESG commitments. And again, I'll give you one example. It's an example from the US, unsurprisingly, but you had the Tennessee Attorney General launching a suit in 2023 against BlackRock under the Tennessee Consumer Protection Act, saying that BlackRock was not or failed to adequately disclose the extent to which ESG considerations influenced their investment strategies, and that thereby they deprived investors of the opportunity to make informed investment decisions. And again, this case settled now earlier this year, with BlackRock agreeing to enhance transparency in proxy voting, BlackRock agreeing to improve compliance, and also, and that is quite significant in my view, agreeing to prioritize financial interest for products or funds where the main or the only objective was or is financial performance.
Thank you. Now, I'm interested in speaking about the shareholders' perspective. So do we see any different shareholder actions now in the new environment? And what does it mean exactly for asset managers?
I think there also you have this duality, these two approaches, because on the one hand, shareholders still resort to litigation as a tool for ESG enforcement. And I'll just quote the Client Earth versus Shell case, which was a case of attempted derivative action brought in the UK. So Client Earth as NGO trying to bring a derivative action, so an action on behalf of the company against the company's board for alleged infringement of duties to promote the company's best interest and success, for alleged failure to exercise reasonable care, skill, and diligence. And this was really with the aim of challenging Shell's climate change risk management strategy and also the response to the case and claim that we mentioned earlier. But this case was dismissed because simply the UK judge thought that there was not sufficiently prima facie a case for this to proceed. And then on the other hand, you have shareholders who just go into the opposite direction and use litigation as a means to fight climate-related initiatives, or also shareholders who just vote with their feet or their money. And again, I'll give a US example. But last year, the Texas Permanent School Fund announced that it was divesting about 8.5 billion from BlackRock due to what they felt is or was an anti-Texan stance by BlackRock, or in other words, an alleged energy companies boycott, which they felt that BlackRock was taking via its then policy towards fossil fuels. BlackRock, of course, called these ill-conceived and pointed to the more than 170 billion that they had invested in US energy companies. But I think there you go. Yeah.
Thank you so much. So moving over to the fourth topic we wanted to cover, the project and permitting risks. So Daan, how does ESG litigation now intersect with project development and permitting in this polarized environment?
Yeah, thank you, Maren. And I promised to say a few words on administrative law. And I see people nodding off by hearing the word, but hang on. It's nearly time for drinks. After us, still one other speaker. I just wanted to flag that in terms of dealing with, for instance, the climate issue, which requires the energy system to be innovated, which requires to a large extent a transition away from molecules towards electrons, which requires building stronger electricity grids. Those are huge building projects which will have in and by themselves a certain environmental impact. And there are already quite a few examples, for instance, in my country, of where there are proposed projects to build CCS installations or to build a new switching system for the power grid, where environmental groups are actually filing lawsuits against the permitting authority or the government because it would allegedly surpass certain emission limits for depositing nitrogen oxides, or it would hurt a certain local wildlife or biodiversity. And I'm flagging this to show that the litigation arena around building the systems for the energy system for the future and to make sure that economies can still compete in ways that are less impactful to the environment and the climate still also elicit conflicting interests within the environmental world. And it will in any event cause delays. There was a big offshore CCS project in the Netherlands that was held up for almost 2 years because of a nitrogen deposits concern, which was ultimately thrown out by the highest administrative court. But it is something that if you want to do, for instance, impact investing in companies that are actually trying to build the infrastructure of the future that we need to rely on as societies, that you factor in these delays. And of course, as any investor knows, delay costs money because in the meantime, your costs go up, all your calculations about when you break even in a project become outdated. And regulations may change in the meantime as well. So there is a lot of sort of uncertainty surrounded by these huge projects. And I'm not saying that you should not invest in them, but you just should be aware of the headwinds, even from perhaps unsuspected angles that you might encounter in these things if you put your money there. So that's what I wanted to say about that. Thank you.
Thank you very much. Before we conclude on the panel, Ada, do you want to add anything from the asset manager's perspective?
Yeah, I think it's currently really a situation of crosshairs and needing to juggle with both ESG compliance and ESG resistance. So I think that the stance to be taken in this context that we're currently in is a stance of being aware of the risk of litigation from climate activists, but also from anti-ESG actors, dealing with that duality. Also being aware and preparing for regulatory divergence between the various countries in which you operate. I think the US and the EU are stark in stark contrast in that respect, but also ensuring that when climate targets and commitments are put forward, that they are credible, defensible, and not overstated. And Daan, we went to see a client earlier, and I think the concern around putting forward commitments and committing to the right extent without exposing yourself to claims in this respect is really the most acute concern now.
Thank you very much to both of my panelists for having shared your perspective. It's not the, let's say, most nicest panel to speak about risks, litigation, claims, of course. This is probably why we are at the end of almost at the end of the conference. But I think it just has also underscored really the importance and significance of climate litigation that is just there. So everyone needs to follow it. The transparency towards stakeholders has been really clear and pointed out. Regulators are focusing on it, so it's just an area to watch. But I think if you comply, if there's transparency and consistency in the approach, you should be able to juggle throughout the uncertainty that we are currently experiencing. With that, enjoy the rest of the conference. Thank you very much.
Thank you. That was a really interesting yes, I wanted to ask if there is one question. Yes, we have one question. Just okay. That's fine. Yeah, we can take one or two quickly because I think it was quite interesting.
I have a question regarding passive ETF. They are quite successful at the moment. So if there is something wrong, do you litigate with the index provider or with the asset manager?
Sorry, I'm not sure we could quite hear you. I think the connection was a bit bad in the beginning.
Okay.
If you wouldn't mind repeating the question.
So I was saying that passive ETF are quite successful at the moment. So if there is a problem, do you litigate with the index provider or with the asset managers, which packaging against the index?
Interesting.
Well, because it is a passive fund, but I'm trying to figure out a good answer, so thank you for your question. And the clock is running. I think the most likely scenario actually is that the fund itself would be a claimant against the company that is part of the index that is being tracked. Ultimately, the investors in the fund, they are, well, economically the beneficial owners, but legally it's likely to be the fund or the person acting on behalf of the fund. If the fund has no legal personality of itself, depends on the structure, that would then find itself to be a claimant. I don't think it is terribly different from a classic shareholder class action where institutional investors sue a company. So I hope this gives some guidance and answers your question.
Thank you very much. That was really interesting.